Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about good faith and bad faith. Cases that should have gone to the Supreme Court of Canada, but didn't. Andrea Molnar was convicted at trial of possessing marijuana for the purposes of trafficking. She appealed her conviction, arguing that the trial judge had not properly found a charter breach in her case. And while the Court of Appeal agreed that there was a charter breach, the Court of Appeal engaged in its own analysis of whether or not the evidence should be admitted under Section 24(2) of the Charter, determining that the officers were acting in good faith, and therefore the evidence was better off to be admitted rather than excluded. Ms. Molnar appealed and sought leave to the Supreme Court of Canada, which was not granted. She argued in her leave application that the Court of Appeal erred, effectively by engaging in its own analysis of the effects of 24(2) without the benefit of findings from the trial judge, and also in failing to consider the fact that the arrest without lawful grounds should give rise to a finding of bad faith in the first instance. This case is very interesting because of the way that Section 24(2) has evolved in the last decade. It used to be the case that if there was a breach and there was some type of coercion into providing evidence, that the evidence would automatically be excluded under an analysis called Stillman. Now, because of the fact that the Supreme Court of Canada rewrote the test and it involves more weighing of the evidence, things like good or bad faith become very important in the determination of whether or not the evidence should be admitted. When a court of appeal doesn't have the same evidentiary record that the trial judge did to make these determinations, doesn't have the benefit of hearing the same types of submissions from counsel, and the benefit of seeing and hearing the witnesses in person, and the way in which they give their answers on the stand, it makes it harder for them to make those determinations. So doesn't it become a more important issue to send it back for a determination by the person who tried the case about whether or not the evidence should be admitted? And shouldn't Court of Appeal judges be reluctant to engage in these types of analyses without having the proper foundation for doing so? Unfortunately, the Court of Appeal in this case was found to be essentially correct for having done so. The Supreme Court of Canada denied leave, and the process stands. But maybe it deserves revisiting, and hopefully another case will take it to the Supreme Court of Canada and find this approach doesn't exactly reflect the nuances of how evidence comes out at trial and properly protect the rights of individuals who have been breached already by the police. Hopefully that case gets there soon, so other people facing charter breaches and applications for exclusion of evidence can have some confidence in the outcome of the process. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for producing these videos, and tune in next week for another exciting episode.